Let us now go to the first area of the five that we are going to discuss, the one to do with constitution amendments. I'll broadly set out the current position. As of March 2026, we had 106 amendments to the Constitution. That is almost one and a half for every year of our existence. America is at 27. So we obviously seem to make it simpler. There are three kinds of constitutional amendments: a simple majority one, and one with a special majority, where two-thirds have to vote, and then a special majority requiring state ratification. Now, the report proposed a significant change in all these things. Why don't you elaborate and tell us about the changes and what you think the advantages of the changes are, and perhaps some of the disadvantages of the changes are?
I strongly recommend for acceptance the suggestion made by the committee to make it difficult to amend the constitution to take away or abridge fundamental rights. In fact, in 1965, the Supreme Court flagged this paradox where you could take away fundamental rights by a majority, but if you want to amend another article involving some state subject, you require the ratification of all the states. So something so precious as fundamental rights did not require ratification. So this was flagged by Justice Hidayatullah, and he said that our fundamental rights, the playthings of the majority. That's the word Justice Hidayatullah used, playthings of the majority. So I think one recommendation which I've always thought necessary was fundamental rights should become capable of being changed only by a three-fourths majority, so that they are insulated from changes by a simple majority. Today, if a parliament out of 500 seats has three-fourths majority or more than two-thirds majority, they can change important fundamental rights. So that recommendation of the Joseph Committee or the Interstate, I think I'll call it the Union State Relations Committee, is worth including in the Constitution.
Questions like not only majority of two-thirds of the states, but states with two-thirds of the population, which is completely new. Is that sensible?
No, I don't think that is viable. Also, they have recommended adding a clause to include that basic structure cannot be amended. That's not necessary. It's already part of the judgment. And they've also recommended that a constitution bill must be introduced 3 months in advance and should be subject to public consultation. That's also is a good suggestion. But two-thirds of the whole state, etc., will be impractical, not necessary.
Also, if I could ask you about the basic structure, even if you wanted to put it, how would you define it? I think in 1964, Justice Potter Stewart said in America that, when I see pornography, I recognize it, but I can't define it in words. So is basic structure one of those things which you can see, but not define? And if you can't define it, how would you put it in the Constitution?
See, this is a oft-quoted criticism of basic structure that it's an undefined term, it is vague, and so on. But I think that criticism is not valid. It is by people who don't understand the basic principles of of constitutional law. In 1965, before Kesavan Bharati came, in the Sajjan Singh case, Justice Mudholkar said that, you see, by 1965, the constitution had been amended 17 times. So, as you put it, it was almost one amendment per year. And various rights had been taken away. So, Justice Mudholkar said it's time to press the pause button. How far can you go on amending the constitution? And he asked a very important question. Suppose in the constitution you take away the right to equality, you take away the right to life, you take away the right to free speech, then can you call what remains a constitution at all of a republican democracy? Can you think of a constitution of a republican democracy that doesn't have the right to free speech, right to life, and right to equality? Then what is left? So he said, where do you? So he ironically referred to a Pakistan Supreme Court judgment and said there are certain essential features of the constitution you can't touch. Then the question, what are these essential features? And Justice Mudholkar very nicely says, look to the preamble. What are the essential features? Liberty, equality, fraternity, social justice. These are the essential features of the Constitution. So if you take that away, equality, liberty, all parts of the basic structure. And now one more thing, Kesavan Bharati is now 53 years old. The Supreme Court has laid down norms for basic structure. And other thing is that it's only on 5 or 6 occasions that a constitutional amendment has been struck down on basic structure. So by and large, courts have supported the wisdom of the legislature, of parliament in amending the constitution. It's only on certain cases where they have said, no, you're going too far, and then they have struck it down. The last being the National Judicial Appointments Commission. The very flexibility of this term is its strength. Like there is no definition of due process in the American Constitution. But as years go by, we don't know what will be necessary 10 years down the line, 20 years down the line. So, a concept which, as you mentioned, is easy to understand but difficult to define, its inability of definition may be its greatest strength. It can be molded to meet the necessities of generations.
One of the suggestions made in this segment of the report concerns amendments that run its course after 15 years and get run out. But the question is that amendment this important and useful is no longer available after 15 years. No, unless it's reenacted that period. There could be a very important amendment that is very useful that for political reasons cannot be reenacted. So we are then deprived of that amendment. Is that reasonable?
I don't think that is practical, because how do you identify those propositions which are required after 10 to 15 years? Which are the, the suggestion is made that you make a list of provisions which require rethink every 10 years or every 15 years. Now, take for example reservation. The first they said reservation should not last more than 10
Correct.
years, but you have kept on
15
continuing
years.
it indefinitely.
That they should cease
So,
to have it.
I don't
Unless
think
reenacted.
this is a practical suggestion, making
Which
a
is very
schedule
difficult.
and saying that out of 375 articles, put 20 in some schedule which will be re-thought of every 10 years. I don't think it's necessary.